We are a registered campus group at the University of Toronto since 2012, and we are very glad to see so many of you that have come out here tonight. Our goal tonight is to ensure that the event provides a maximum opportunity for dialogue and public engagement on tonight's topic. The University of Toronto has been a terrific partner in working with us to create a safe space on campus where people can hear about important issues that go undiscussed in most other forums. Towards that end, let's get some housekeeping out of the way, which Edward will fill you in.
In order to guarantee the fair and equal treatment of all parties, the University of Toronto's policy on the disruption of meetings is in effect tonight. If a disruption occurs which interferes with the progress of the meeting, we will ask that all those responsible desist and remind them of this policy. Should the disruption continue, those individuals will be asked to leave. And if all else fails, the event will be temporarily recessed so that campus security can decide how to proceed. I do want to be clear that we're not expecting anything of that nature, and if it does come to that, please be patient as we will work to get things going again as quickly as possible. I do also want to let everyone know that this event is being recorded for later playback online, and it's also being live streamed on YouTube and Google Hangouts. Later on, when the audience can offer questions, they'll be available through those as well. In addition, others may be recording the event for their own separate use, and people are welcome to record, stream, or otherwise report on the event so long as they aren't causing a disruption. We greatly value transparency in all of our activities, and we do particularly encourage others to respond and discuss all of our events.
So before we continue, just a little bit about UTMIA. We've hosted engaging and insightful monthly public lectures on men's issues since 2012. Some of you are already familiar with our work and have attended our previous events on campus. For example, last month we discussed misandry with men's studies giants Young and Nathanson, and the months before we facilitated successful dialogues on men who are victims of domestic abuse and trauma. And other events on the declining status of fathers and the disastrous consequences on their children. For those of you who have already been a part of these events, then you know that our talks are peaceful, educational, and open conversations. We encourage differences of opinion. Our events are models of how sensitive topics ought to be discussed respectfully. We hope we can continue to come together to preserve the university as an open space, free of threats, free of intimidation, and where the exchange of ideas on critical but sensitive issues can still occur. Apart from the university, we do believe that there are very limited places for such discussions. So please join us, sign up, and donate what you can to further free public talks and events at the University of Toronto on men's issues. We are the University of Toronto Men's Issues Awareness Society. Help us to provide access for university students to respectfully hear all sides of the conversation on gender studies today. You can find us on Twitter at #mensissues or #UTMIA. So, our events, as mentioned, are sponsored by the Canadian Association for Equality, also known as CAFE, and allow me to introduce at this time CAFE's Executive Director, Justin Chautier, who will say a few words before we move on to the main event.
Oh, thank you, Edward and Yola, for that introduction to tonight's event. I'm just going to say a few very brief remarks on behalf of the Canadian Association for Equality, which is privileged to be sponsoring this event tonight. We're a registered educational charity. We support all efforts at achieving gender equality in Canada. Our focus is on the health, status, and well-being of boys, men, and fathers. where we believe public policy attention and social service and resource support are significantly underdeveloped and understudied. We value the human rights of each and every individual, and we believe that men and boys share a common collective interest with women and girls. We believe that through promoting the health and welfare of any individual, that all will benefit. Our approach to gender equality is inclusive, diverse, respectful, affirming, and led by facts and evidence. And while we're speaking of our values, of particular relevance to our public event series, and certainly tonight's event, is the value that we place on dialogue and the respectful exchange of ideas in order to foster mutual greater understanding, values we share with the University of Toronto. We also strive for transparency and accountability in all that we do. So what is it that CAFE does? Well, we sponsor public events like tonight, all across Canada. We host something called Equality Canada TV, which brings you interviews, news, and commentary on men's issues and gender issues. We engage in research and policy work that push for inclusive public policies that don't leave anybody behind. We undertake consciousness-raising initiatives that discuss life and death issues that go often ignored, whether it's the startling rate of male suicide or the lack of support services for male victims of domestic violence, the consequences on a child of being deprived of their father, or the unique ways minority men face particular disadvantage. You won't hear these issues talked about in many other forums. We also more recently have opened a social service facility so we can actually begin to provide solutions to some of these intractable problems. It's called the Canadian Centre for Men and Families. We provide men's health services, we provide legal assistance services, we provide support to male victims of domestic violence and abuse, and we also do a number of programs with other community agencies. You can learn more about our programs at menandfamilies.org or equalitycanada.com, two websites, lots of content on both. You can follow us on Twitter at equalitycanada, #mensissues. So thank you for your attention, and I'm going to turn this back to, is it Edward or Yola? Edward.
Thank you very much, Justin. Tonight, the trial of Ghomeshi brings us together to confront many of these questions directly. On behalf of the University of Toronto Men's Issues Awareness Society, I'm pleased to be able to present to you an all-stone panel which has been brought together by the Canadian Association for Equality in the aftermath of the verdict we heard just 2 weeks ago. Our guest moderator for tonight will be Lorne Honickman, a litigation lawyer and longtime radio and TV broadcaster. Lorne is also a legal analyst for and a regular panelist on The John Oakley Show on AM 640 radio, and in the past has been a reporter for City TV and a legal specialist for CP24. Lorne will be introducing our guest panel and moderating tonight's discussion. Please join me in welcoming Lorne Honickman and our honored guest panel, Christie Blatchford, David Butt, and Richard Litkowski to the University of Toronto Men's Issues Awareness Society ongoing public lecture series. Thank you all very much for coming, and thank you, Lorne, for agreeing to moderate for us tonight.
Thank you. Okay, let me, it's going to be handheld. Okay, no problem. All right, well, thank you very much, everyone. And it will be, and hopefully will be, a very interesting discussion tonight. On March 24th, when the decision came out, I was asked by Global TV if I wanted to do a quote, a live hit at Old City Hall to talk about it. And in my career in television, I had done a lot of live hits. That live hit was about 3 hours in the ice storm in front of Old City Hall, and I could not believe the interest in the emails that I got and the phone calls that I got with people wanting to talk about this case. And then when I was asked to be a moderator tonight here, I thought it made sense to keep the discussion going. So that's what we're going to do. We're going to talk about a lot of the issues, talk about what came out of the judgment, talk about where we go from here. A lot of people, as you know, when you talk about polarized opinion, this may be the case for now. There will be another case in the future, just like there were cases in the past. But for now, this is the case that's polarizing opinion, and it's causing a good discussion. And that's what I'm going to urge we have tonight, a good discussion. I had no idea that I would be dealing with the word disruption at all until I came here and I was told, remember, Lorne, here's what you have to do if there's disruption. So I'm going to step back and say there's not going to be disruption because there's no need for disruption. We're going to have lots of opinion. We know opinion, as I say, is polarized, and there's no problem. We'll go through the questions, we'll go through the issues, and then we'll open it up to the floor. We got microphones on both sides. I'm going to anticipate there's going to be a lot of questions, and we'll try to limit it to about 45 seconds. Let's not have cross discussions. We'll put the questions to the panel, and that'll open it up. And we'll hopefully, we're not going to go through everything. We can't go through everything, but the important part of it is to keep the discussion going. Let me introduce the panel. Closest to me, David Butt. He's been a lawyer since 1989, and David has seen it on both sides in a courtroom, Crown Attorney for, I think, what, about 15 years?
13.
There you go. I gave you another 2 years. So 13 years and now defense counsel. Beside him, Richard Litkowski, who has been defense counsel, I guess, since 1991, right? And spends his days in the criminal courts. And beside him, Christie Blatchford. Now, before I started to practice law full-time, I was able to say that nobody ever covered more legal proceedings in this country than I did as a reporter. She has passed me way down the road. Nobody, I think, in this country has done more legal reporting and as good legal reporting as Christie Blatchford. And that is your panel, and I'd like to give them a welcome hand. All right, so what we're going to do is I'll set some questions out, just some by the way, these, I don't really need these. I just wanted to, this is, as a lawyer, as you'll tell you need it as a prop. So I just use it, and I think it works well, especially since we're live streaming. I'll put them on, I'll pretend I'm in court right now. Okay, there we go. So let me start with this, and again, I know that we'll be very civilized up here. There will be no disruption on the panel. So I'll throw.
Speak for yourself.
So I'll throw out the questions, and let's get the discussion going. Before I start, I just would like to know a show of hands. This is the judgment. How many people in the audience here have read the judgment? So we've got what about half? And it's an interesting read. It's about 140 paragraphs, and the trial and the judgment, as you know, focused heavily on the issues of credibility and reliability. And one of the interesting questions and concerns that came out of that was whether or not an alleged victim who has come forward, their credibility, should it be as important in a sexual assault case, and what should courts do when determining issues of credibility? In other words, is there anything that should have come out differently than what Justice Horkins did, or is that how a court must view the issues of reliability and credibility? And I'll start with you, David.
Yeah, my own view is that, and you know, as things unfold later in the discussion, I'm going to suggest that the criminal courts are not particularly well suited to deal with relationship violence, broadly speaking. But you know, if we want to contemplate alternatives and have that discussion, there really has to be a baseline. And to my mind, the baseline is that, of course, you always have to have accurate fact-finding. We are only ever going to heal and move beyond disruptive, violent events or alleged events if we have the capacity to engage in accurate historical reconstruction. And so that to my mind is a baseline, that however you approach these issues, there's no way that you can responsibly abandon astute fact-finding.
Well, Richard, let me just go to you quickly. On that point alone, there will be some who will say that this was simply a fact-specific case dealing with 3 specific alleged complainants, and the analysis on it goes specifically to that case alone and not beyond.
I think that's right. I think there's nothing unusual or extraordinary about this case, aside from the fact that it had a high-profile person accused, and it drew enormous media attention, mainly for that reason. These are cases that are tried in the courts in Toronto, across the province, on a daily basis. in the provincial courts, in the superior courts, for judges alone, before judges and juries. And those triers of fact, that whether it's a judge or a jury, will always face the same essential questions. And they come back to what Lorne said, credibility and reliability. And it's important to keep those two things separate. Credibility relates to the truthfulness or sincerity with which a witness gives evidence. That is the primary assessment that any trial judge has to make. Reliability is a separate issue. Reliability goes to the content of that evidence. Is this witness giving evidence that, as David said, is historically accurate? Does it represent an historically accurate recitement of what occurred? So judges typically, and judges tell juries, to look for certain indicia of credibility. They've done this for centuries. So, and Lorne, if you want me to go on to explain some of what they are, I can do that. But this case, in my view, is not any different than any other case that many trial judges deal with on a daily basis across the province, across the country.
Well, Christie, let me follow on that, because one of the many, and we can underline many questions that came out of this on the issue of credibility and reliability, was the issue of preparation. Heard a lot of people talk about, well, were these complainants properly prepared for what happened at that particular trial? And so I guess that could lead to the question, what effective preparation would look like. Was that one of the issues, one of the concerns that came out of this trial?
I think it was. I think these complainants were prepared by the police and prosecution ordinarily, minimally, in other words. The Toronto Police Sex Crimes Unit has certainly had at the time, was headed by a woman who said several times in connection with another case of sex assault victims, we believe the victims 100%. We always believe them. There's no question of that. And that's a preposterous attitude, frankly, for an investigative agency to take. You know, you don't take the word of, you do at first blush. You accept that somebody is making a complaint. You certainly take their complaint seriously and you report it as a crime. But beyond that, you have to investigate it. And I think the police investigation in this particular case was minimal and, just going through the motions, because that's what they do, I think. And they're not alone. It's very common. The prosecutor has a very tiny role in preparing any witness, so he's not really at fault in that sense, I think. And all three complainants, it is worth noting, had their own lawyers. So they were better advised than probably the ordinary sex assault complainant, and certainly better than most other kinds of complainants in other crimes. And in addition, of course, they were also accompanied into the courtroom every day by the people I call the pit bulls from the victim witness office. These are the soothers. They accompany every woman or every child into a courtroom and hug them. I'm not making this up. That's what they do. They're soothers, but they're ferociously protective of the witnesses so that they're, you've seen it, Lorne. I'm sure you've all seen it. So that's the bottom line of that.
All right, and let's take this a step further on this reliability, credibility, and the preparation, etc. There were so many important paragraphs and lines that came out of the judgment, but one of the things that Justice Horkins made clear, one of the many things, he said, "My conclusion that the evidence in this case raises a reasonable doubt is not the same as deciding in any positive way that these events never happened." Now, in my mind, an important finding. Let me ask you, David, when he finds that reasonable doubt is different from deciding that an event didn't happen, why is that a meaningful distinction?
It's a meaningful distinction because if we are going to impose the severity of a criminal sanction, we need to have a very high degree of certainty before we impose it. And I'm not, in saying that, speaking as someone who thinks that the status quo is appropriate. I happen to think it's inappropriate, and let me explain why. That standard, a very high standard for the imposition of criminal liability, is something that I support. I do not support lowering the standard of proof in a criminal court. What I do say, however, is that we're failing to serve a very significant constituency. If you look at Stats Canada data, out of every 1,000 sexual assaults, only 33 get reported in the first place. So we've got an abysmal fall-off rate. People are voting with their feet and just staying away from the criminal justice system. Of the 33 that are reported, only 12 lead to charges. Only 6 go to trial. And only 3 result in conviction. So if you add up those numbers, there's a 99% failure rate, 99.7% failure rate in terms of servicing that community. Any service agency delivering any kind of service, I don't care what it is, and I don't care if it's in the public or private sector, if it had a 99.7% failure rate, you'd say, we got to redesign this from the ground up. So what I say is, keep proof beyond a reasonable doubt. You need that high standard for protecting against conviction of the innocent. But limit your criminal justice response in a lot of these situations to the very serious serial predators who need to go to jail for a long time, and give those other, sort of 997 folks who are not getting what they deserve different options. One option is a lower standard of proof. And why is a lower standard of proof outside of the criminal justice system a better way to reconstruct history? Well, let me put it to you this way. If somebody tells you, tonight it's probably going to rain, what would you do? You take your raincoat or your umbrella. In a criminal court, if the conclusion is that person's probably guilty, what do? You acquit them. So that's just like saying it's probably going to rain. You cannot take your umbrella or your raincoat. We've made a conscious decision to depart from an everyday common sense standard of holding people accountable in criminal courts because of the high consequences. But as a result, we're failing to make findings about historical reality in far too many cases. So I say, we're not going to change the criminal justice system. We're not going to lower that standard of certainty. Let's move some of those cases elsewhere where we can have more nuanced fact-finding and be more responsive.
I'm just going to interrupt you for a second. I just want to let to use the legal parlance inside a court, let your friends respond to that. Your friend over on the right side, Ms. Blatchford, do you have a response to that?
Sure, I do, and I spent the entire day in coroner's court where I listened to lawyers wank on, so you'll forgive me if my patience is at a kind of limited.
Sorry, can I just, you said wank on?
Yeah, I know
Okay,
this is a safe space and sensitive and all of that, but I'm afraid I am not cut from that cloth, shall we say. First of all, I think the numbers are shocking, but I also think the numbers can say what you want them to say, as is always true of numbers. In the United Kingdom in 2010, I forget which dame it was literally a dame, investigated the way that rape, they still have rape in the United Kingdom, was being handled by the Metropolitan Police, the Scotland Yard. And the woman who wrote the report found that with sexual assault or with rape, there's a tendency to sort of mix apples and oranges. And the apples are the number of complainants who come forward to the police with other kinds of numbers. There's a lot of cases that disappear in the criminal justice system, not just sexual assault cases. If I go tomorrow and accuse Lorne Honickman of slapping me in the face, the police will write it down and report it as an assault. But then if I, the next day, come in and say, we were just having a quarrel, he's kind of a jerk, so I decided I'd complain about him, I'm sorry. A great many of the original complaints disappear, I forget what it's called, attrition. And then complainants change their minds, et cetera, and particularly with, when you're making allegations that involve sex, and often they are he said, she said, by definition cases, if the complainant withdraws, the police have no way to go forward, really. So I think we have to be careful just to what the numbers say. This study in the UK came up with, actually, if you count rape the way you count murder and not screw it up with other numbers, you end up with about a 58% rate of conviction of all cases in England, and I think it would be 54% in Canada. So that's all I would say. And I mean, I appreciate David's point that you don't want to mess with the high standard of proof that's required in the criminal courts, because people go to jail. They lose their liberty. I mean, I spent 62 days of my life not too long ago covering the Mike Duffy trial. And Mike Duffy's lawyer used to whirl around routinely and point at his client and say, this man is on criminal trial for his liberty. And, you know, it got to be a bit cheesy, but it's true. So we don't want to lower that. I don't know if David is suggesting the civil courts should be used more often. Maybe so. But the only other alternative that I've seen is trial by press. I mean, the Ghomeshi case began with anonymous complaints made to a really good Toronto Star reporter, but he's not a trained investigator, and he would admit that, I think. The trial, or the civil complaints against John Furlong, who ran the Vancouver Olympics and was then accused of sexually abusing people when he'd been working in a northern school in northern BC, was started by a journalist. I mean, journalists have a lot of responsibility to bear in some of these modern cases.
All right, we're going to get to the court of public opinion in a moment, because I think
that's the court of press opinion, and that often leads the criminal investigation.
Well, it leads to both sometimes, but I want to let Richard get in on this, because David has put it out there. He's put it out here early in the discussion about alternatives to the criminal justice system in dealing with some of these.
You've been told.
Yes. Richard, is there a place for the civil justice system? We'd be talking about a balance of probabilities, not on beyond a reasonable doubt. We talk about restorative justice. I know David has spoken about that, perhaps mediation. Are these areas that need to be explored?
Well, those areas exist. They exist right now. The three complainants in the Ghomeshi matter are quite free to sue Mr. Ghomeshi civilly if they wish. Nothing prevents that. But let me get back to maybe a bit just to address the distinction between the civil process and the criminal process.
Yes.
We often hear people waxing eloquent about how the trial process is, in the criminal context, is a search for the truth. Well, I'm sorry to disappoint you, but it's not. In a criminal process, in a criminal trial, the focus is on a search for a reasonable doubt. That's the focus, because the onus is on the Crown to prove the case against the accused beyond a reasonable doubt. Judges tell juries that when they're charging them at the end of a case, you're not investigators. You're not there to find out what happened. You're there to assess the strength of the Crown's case and to see whether it met the high standard of proof beyond a reasonable doubt. Now, with respect to David's use of the statistics, I'm going to pick up on some things that Christie said. First of all, with respect to reporting crimes, yes, reported sexual assault allegations are at the very low end of the spectrum. But according to the same, I think, statistics that David is relying on, across the board, less than a third of all criminal acts are ever reported to the police. Less than a third. Across the board, we're talking about assaults, simple assaults, robberies, mischiefs to property, all crimes. So the reporting rate has to be put into context. The public generally does not rush to report a lot of things to the police, as Christie described.
So it's okay to have a crappy reporting rate in sex assaults because you've got a crappy reporting rate for everything. It's all good, right? Because it's all bad.
I didn't say that, David. My point is addressing the issue of putting statistics into their proper context. The second point with respect to the rates of conviction, Christie's absolutely right. I have the statistics in front of me. The homicide rate of the homicide percentage of guilty findings is 53%. Sexual assaults are 45%. The acquittal rates for homicides are, if I'm reading this correctly, 8%, sexual assaults 9%. That's numbers in context. Do we have a problem across the board with people not reporting crimes or alleged crimes to the police? Yes. But is it because of the nature of the crime? Not necessarily. Of the 967 alleged non-reporting of sexual assaults, the same statistics that David mentioned demonstrate that 71%, approximately, of those people who did not report because they said the crime was minor and not worth taking the time to report. Numbers need to be placed in context. Finally, with respect to the civil process, now David has more recently on The Current, I believe, with Anna Maria Tremonti, spoken about using the civil process, but at the same time using crowns, if I'm correct, and the same investigative agencies that would prosecute a crime in a criminal court to do the work in basically bringing forward a civil complaint, a private complaint. That leads to a lot of serious questions. First of all, that same complainant who's going to go through the process of a civil action will have to face the same cross-examination, or perhaps even worse cross-examination, than that person would in a criminal case. Because in the civil case, you have examinations for discovery, where the plaintiff can be discovered. You have the ultimate trial. As well, who's going to pay to defend the individual who's accused in the civil context? The complainant, under David's scenario, will have the state funding the investigation, the accumulation of the evidence, and the prosecution of the private case against the individual. I do a lot of legal aid work. Trust me, it's not easy to get funding from the government to represent people who are accused of sexual assault or any crime for that matter. So imagine the scenario of going down to the government saying, not only do we want funding for representation on criminal cases, but we want this person to have funding to be represented against a civil complaint. So I understand that David is concerned about the lack of reporting and giving complainants who do not go to the police some alternate means of having their claims addressed. But it's difficult, in my respectful view, to see how practically this state-sponsored private complaint process in the civil context is going to practically work.
Can I just
Yes, please.
speak to that? I take issue with the notion that you can dismiss it by calling it a private remedy. The sexual integrity of everyone is an issue of public importance, and that's something that we should be committed to as a community. And if we are not, because of the necessarily high standard of proof, able to pursue proper historical reconstruction as a foundation for delivering justice in a large segment of cases, we have to look at alternatives. And I acknowledge it's a tremendously heavy lift to get any money out of government for anything. But I don't take the attitude that it's sort of defeatist to say, oh, we'll never succeed, so let's not even try. Let's not even talk about what that would look like and how it could look better and yet still remain fair. Because right now, where it's purely a private remedy, you'll get, maybe if you're lucky, 50 grand in a civil sexual assault judgment. You'll probably spend 150 grand in legals to get there. It's simply unavailable to anybody but the richest. So, but I think that taking a stand on sexual violence is something that should not be means dependent. It should not be available to only the richest in our society. So I think that we have to deliver a mechanism that responds to the reality of sexual violence more broadly. And if we have to move, outside the criminal justice system to do that, let's look at ways to do that. Do it fairly to everybody. I agree with Richard that the respondent in a civil case it's a worthwhile investigative question. But let's be more comprehensive in delivering our response to the reality of sexual violence.
Well, let me ask you the question. For the alleged perpetrator, what are the ramifications of any of these other potential remedies that you're talking about, David? And I'll put this to the whole panel. What's the ramifications to an alleged perpetrator who says, from the beginning, I did not do what I'm being accused of, and now and it may not be, to use your example, it may not be a tremendously serious on the scale, but it's still an assault, an alleged sexual assault. What about the alleged perpetrator who says, I didn't do it, and now he'll be facing a standard of proof that's on a balance of probabilities, not beyond a reasonable doubt? Should we not be concerned about that?
No, because we have that system right now. The only problem is that it's economically unavailable to the huge everybody, but except the 1%. All I'm saying is make that more broadly available. Nobody's, I think, would argue that our civil justice processes are fundamentally unfair. I certainly don't take that position. I don't think anyone else here does. Let's just make that available remedy more broadly available to those who could not otherwise afford it. The other thing is, Richard spoke about the organs of the state in terms of investigating. Any clown who wants to pay a lawyer can issue a statement of claim right now privately. There's no vetting process. There's no professional requirement of responsible investigation. I say if we move to a system like we have in some jurisdictions, for example, the United States, U.S. attorneys can move either criminally or civilly, depending on what they feel best responds to the public interest. If we have that, we also have up front an independent investigative agency gathering the evidence, and doing so, one hopes, objectively and fairly. And so I think that can be a model that enhances the fact-finding process and makes access to justice in sexual violence situations much more broadly available.
I don't think we can be quite so cavalier about the ramifications on the perpetrator, especially if we were to move to the more civil actions, because the ramifications of being accused of being a sexual attacker, a pedophile, a child porn, whatever, are so enormous you cannot recover your reputation. In the modern world, you can't. I mean, John Furlong is a pretty good example. He was never charged criminally. He was investigated upon a complaint from a person who claimed to be a former student. The RCMP locally did an investigation. They couldn't find it. There were all kinds of inconsistencies with the complainant's story, chiefly that she hadn't attended the school where she says she was abused. They then went to the civil courts. There were 3 of them, 3 separate complaints. And the whole while, I mean, the process worked. He was not, the claims were dismissed. But throughout that whole process, everyone in this country who had previously thought so very well of him thought, oh my God. I mean, he told one reporter, a former colleague of mine, after it was all over, that when he was accused, never charged, and certainly never convicted of anything, when he was accused, he had a Rolodex. He was an old school guy, I guess. He had a huge Rolodex of friends and contacts, and virtually the entire Rolodex died because of those allegations. So if we're going to do this, whatever we do, we have to be very aware that people, they may not go to jail on the civil side, but they will be reputationally devastated.
And that's exactly why I agree with Christie totally on that. And that's exactly why I say, as a condition of entry into this reformed way of civil justice, there has to be an impartial, independent, and professional investigative agency that looks at the case, investigates it thoroughly, and then says, yes, this is worthy of proceeding on either a criminal or a civil standard. I agree.
Richard, did you want to, before I move on, did you have any comment on this? I mean, I guess my only comment, I spent so much of my time in the civil law practice, is what happens if the claim is dismissed? Do you get costs from the alleged victim that came forward?
Well, you do in the traditional system.
No, I know.
Because one
you
of the
do.
disincentives for false allegations in the civil process, as David knows, is that you get costs. I mean, that's a huge disincentive for false allegations to be brought. Under your system, David, it would seem that an investigative agency, so-called independent. The same people who are essentially prosecuting individuals criminally are now going to assess whether there's a civil case to go forward. So the independence of that process is, in my respectful view, in question right from the get-go. And so you don't have that disincentive with respect to the cost issue, and I don't practice civil law. I wish perhaps I did, because I'd be a lot richer, Christie, you're right. And maybe I'd get
Talk
costs.
about myths. We'll talk about myths in a minute.
Maybe I could get costs against the police and the prosecution more regularly when they falsely prosecute an accused person. But that doesn't really exist in the criminal process, unless you want to bring a malicious prosecution suit, and good luck doing that and succeeding. So I'm still troubled by what this new monolithic, independent body that's going to now carry the day on civil process is actually going to look like, and how practically it's going to look. It seems to me that it's going to be even more imbalanced with respect to the accused and, well, technically would be still an accused in the sense of an alleged perpetrator, then he's almost in the same position as he would be in a criminal context, except, as Christie said, well, maybe he won't go to jail, but he will be excoriated, probably for a lot longer than he would be in a criminal process, because civil cases, as David probably knows, and Christie, you know from experience, drag through the system a lot longer than criminal cases. So I admire David's thoughtfulness in trying to look beyond the scope of what we're doing now, but the cynical side of me and the critical thinking side of me says there are a lot of problems with this proposition.
All right, well, and I'm sure we'll get back into it when we open it up for discussion, as we talk about David's interesting idea. I want to talk about education, and I want to talk about education and how it fits into our discussion. I found it fascinating that right after the decision came out, Mainstream and Post Media, where Ms. Blatchford works, did this poll and found that 53% of people in Toronto disagreed with the decision. 4 out of 10 lost confidence in the justice system because of the decision. And what I want to throw out, and again, I don't know if this is specific to the Ghomeshi trial, I think we see it, where I said before, the court of public opinion versus the court of law, always a tension between the two. How important was it, and is it to this moment in time, any of the polarizing opinion that may be in this room or across the Canada, how important was it about the facts that came out through the press, through the Toronto Star first, then through Mr. Ghomeshi himself, through his Facebook posting? How much is that, and how important is that, the court of public opinion, in informing how we feel today, or how many people felt right after that verdict? And how important is that on a discussion about reform and what we can do about that?
Well, I think actually the decision did inform people. I mean, if I use my own mailbox as a way of measuring such things, and it's not a very good way, I'm not pretending it is, but I think you could tell. I think the courtroom itself was a pretty good reflection of Canadian public opinion. When that trial started, there was not one soul in that fucking room, I bet, with the exception of the judge, who believed that John Ghomeshi could possibly be innocent. There was the smell of a lynching in the air. And I don't use that word lightly.
Marie Hendon could probably add to that.
Well, no, but she was an advocate,
Yeah,
so
fair enough.
So as the witnesses, complainants, proceeded to self-immolate in the witness box, and it was reported by everyone, including people who did not want to write that. And at first it was cautious, but then it became sort of more obvious. And by the end of it, I think, well, I certainly had a day. I think I went in there with an open mind. I went there hoping to see one of these 3 complainants actually stand up well and tell the truth and all of that. But in the middle of Lucy de Couterre's testimony, I remember distinctly the day thinking, oh my God, what if this incident never happened? And then, oh my God, what if he didn't do it? And I think to some degree, by the end, when the judgment came out, many people in Canada at least ask those questions where they would not have been prepared to ask those questions before. There's a polarized core on both sides of any highly inflamed issue, which is never going to change its mind. And with respect, I would say it's the people who haven't read the judgment.
But I think that no matter what the case is, and Richard, I want you to respond to this, once the police arrest somebody, it is historically always the feeling that, oh, police wouldn't arrest somebody unless they're guilty, and an accused goes into a trial always under those parameters. But what I'm putting out with respect to this case, Richard, even more so because of all of the interviews that were done with alleged victims and Mr. Ghomeshi's Facebook posting itself that wasn't part of the trial, did that add to the fact of why people had, as Christie said, had to all of a sudden have these oh my goodness moments because so much was out before the case?
I think that does distinguish this case from the run-of-the-mill other kind of case that you see in the courts, absent perhaps a high-profile homicide that Christie would cover or her colleagues would cover. But we have a presumption of innocence in law. But Lorne, you're absolutely right. When the members of the jury panel come before the accused, who's sitting in, by the way, something we still call a prisoner's dock, by the way, and sitting there waiting for a jury to be selected, the last thing, in my estimation, that a prospective juror will say to him or herself when they look at that person in that prisoner's box is, there sits an innocent person. That's not the initial reaction. But in law, we're told that that person is presumed innocent in the eyes of the law. But I fear that in the eyes of many prospective jurors, that person is not presumed innocent. And practically during the trial process, the onus is going to be on the accused person to prove his or her innocence. Now, with respect to Mr. Ghomeshi, speaking more specifically about the lead up to it, yes, I mean, obviously there were things that were in the press that were reported about Mr. Ghomeshi's own writings that I would say did affect public perception. The fact that the chief of police essentially went before the media and said, invited alleged victims to come forward. The media attention that was drawn to the specifics of what these particular complainants were saying in the press during the multiple interviews, and Justice Horkinson's decision refers to some of the many media interviews that were given by some of the complainants before the actual trial process. You cannot separate that, Lorne, from the ultimate public perception. Frankly, the fact, and I think Christie's right, people who read the judgment, who understand why Justice Horkins decided what he decided in analyzing the evidence, I'm actually surprised that that's 53%. I'm quite happy about that, because normally you still get people who, despite acquittals, who overwhelmingly still refuse to accept that this person was rightfully acquitted.
So, David, part of the new system, or when we move on somewhere new, if we do, I'm sure there may be people here and others who argue we don't need to do anything different. But for the purposes of the discussion, if we are going to move on, the education factor. The people who out there have used the words that sexual assault victims were, quote, and I've read the words, betrayed by the judgment. Is that not, is an educational component should not it be part of whatever reform we're talking about?
Yes, 100%, and it's fascinating, and I'm going to defer on these kinds of questions to the true pros and the pros among pros, like Christie, we're honored to have here tonight. But from my perspective as a lawyer on the whole publicity, education, and media piece, and by the way, I'm precluded by conflict from saying anything about the particular Ghomeshi case, so I'm only talking in general terms. The reality is that there are limitless sources of both information and perspective on what's going on in our courts now. Everybody's tweeting about it, everybody's retweeting, everybody's picking up on someone else's tweets, and so on. So the public now has access to so much both information and commentary of a complete range of quality, from the most insightful and accurate to the purest garbage. And in any system, whether we're talking about a civil, a reformed, a current criminal, the decision maker, the impartial decision maker who sits and hears the proceedings and then issues a decision, now more than ever has, I call it, a moral obligation to write clearly and to write comprehensively about the decision-making process and why they reached the conclusion they reached, and to write in a way that is accessible to lay people. I read far too many judgments that are just turgid bits of wet cement that only law nerds would love. And I think that is frankly an abdication of responsibility in a democracy of any judicial or quasi-judicial decision maker. So I think, Lorne, the education piece, when there's so much more information and commentary out there on a case, is heightened on the part of the actual decision maker.
All right, because I know we're going to, Justin, we're going to want to open it up to questions in a few minutes. But before we do, let me just ask this, because I got asked this, and it's an interesting, I guess, discussion that comes out of this one. Of course, we start talking about potential reforms, and that is, what do we do about false allegations? They've been around since the beginning of time. I think that there are people, and David, I know you don't disagree because you've worked on both sides, who for their own improper motives or purposes have come forward with false allegations. We know that's happened in this country. Is there any concern at all that the fallout from this case may somehow empower somebody who would have the proclivity to bring forward a false allegation and say, oh, okay, I just got to get by this reasonable doubt aspect now? Is there, in other words, is there a bad, we talk about the messages, is there a bad message that's come out of this in this discussion?
I, for one, am not worried about that, provided this. I mean, that risk is always there. It's a small risk, but the thing about small risks is you never know when they're going to crop up. So you have to be ever vigilant for a small risk. And the importance, to my mind, goes back to a point I made at the very outset. You always have to have very careful, expert, investigative unraveling of the matter before it reaches a courtroom, and you have to have very nuanced, sensitive, and high-quality fact-finding processes. And however we define those are the values that you have to adhere to, and it's only if you adhere to those values that you're going to prevent mistakes from manifesting themselves.
What do you think, Christie? You talked right at the beginning about the police and how they look at these things. Will this perhaps change their way of doing things from your point of view, or the Crown, again, to be more vigilant now?
I don't think so, to be honest. Not just before, but I think about a month or two before the Ghomeshi trial, there were two Brazilian soccer players who were charged with sexually assaulting a woman, a sleeping woman. One of those cases was so weak that the police unusually, in Ontario, the police charge people without asking for Crown advice. It's different in other provinces. But unusually this time they asked, and they got 3 opinions from the senior Crowns to not proceed with this charge against one of these soccer players. His last name was Piazon, I think. And the police, under the hyphenate, I can't remember her name now, God, what's her name? The head of the sex assault, or sex crimes unit.
Joanna Bevins Desjardins.
Joanna Bevan Desjardins. Always beware the hyphenated name in my experience, but in any case. She held a press conference with pictures of these 2 dreadful perverts behind her, knowing that the charge wasn't going to go forward, knowing that the Crown was going to drop it because there wasn't a case, and did this anyway. And I think that that was an outrageous way to treat a young man who is internationally known and was thus then internationally smeared. A couple of months later, I think, under duress and pressure from the Crowns, they finally dropped the charge. So I don't think that this will change much. At the moment in this province, there is a culture of, I believe, survivors. And even the word survivor is actually antithetical to the presumption of innocence. Because if you're calling a complainant a survivor, then you are saying that some assault took place. I don't like the word, I don't use the word. So in this province, though, at the moment, and really in the country, there is a sort of, I think the prevailing wind is to accept, is to believe that women rarely make false allegations, and they rarely do. I'm not suggesting it's a plague sweeping the country, but women and men are equally human and equally prone to lying and equally prone to noble behavior and ignoble behavior. So I've never understood this thing was this sort of view that, well, why would they make it up and put themselves through this? Who knows? They might be mentally ill, they might be vindictive, they might be fucked in the head, who knows? Sorry again to the safe space nature. It's not really that safe here tonight.
Richard, did you want to comment on this before because we should open it up to questions?
Sure,
I know
sure.
Yeah, let's do it.
Just quickly, David mentions the small risk of wrongful convictions, but that small risk, and we can quibble about the size of the risk, brings huge consequences. And in terms of the numbers, I mean, we know from the many public inquiries into wrongful convictions, going back to Guy Paul Morand, Milgard, the 3Ms, as they've become known infamously, Donald Marshall from the East Coast. Those are just the homicides. Those are the high-profile cases. You have the fiasco with Dr. Charles Smith, the so-called expert pediatric pathologist who caused wrongful convictions for men and women who were accused wrongly of causing their baby's death because of an incompetent so-called Crown expert witness who was not vetted properly by the state. So
He wasn't even a forensic pathologist.
he wasn't, at the end of the day, as the Gouge report noted, he wasn't even qualified properly to give that kind of expert opinion. So there are huge consequences to false allegations. And I know Christie will know the name Jamie Nelson. And I brought a National Post article that she wrote back in August of 2001. And she probably knows a bit more detail about this case than I do, but Mr. Nelson was alleged to have raped a woman in 1996. He went to trial. Judge Alone, I think, in the Ontario Court of Justice, was found guilty by a judge and sentenced. He spent, I think, 1,047 days in jail until it was revealed that the person who made these allegations had a history of making false allegations. I think the number was up to about 55 allegations that were proven not to be valid. Ultimately, at the appeal level, Scott Hutchison, I think David's colleague at the time, who's now Marie Hendon's partner in law, and Todd Ducharme, who's now a Superior Court judge in Toronto, jointly, the Crown and the Appellant's Counsel jointly recommended to the Court of Appeal not only that the conviction be quashed, but that an acquittal be entered. And Justice Laskin, the Court of Appeal, did that. So we can talk about, oh, you know, it's a small risk. But these risks bring tragic consequences to people's lives. And that's why we have the presumption of innocence. That's why we have this high onus of proof beyond a reasonable doubt. And that's why it's not a betrayal for a judge to apply those principles. Was Bertha Wilson, when she was the first female judge appointed in 1982 to the Supreme Court of Canada, betraying her gender when she upheld the concept of subjective fault repeatedly in her judgments? Was Justice Beverly McLaughlin, as she then was in 1991, when she struck down the rape shield provisions as they then were in Seaboard, was she betraying her gender? No, she was doing what Marie Hendon said in her interview with Peter Mansbridge. These judges, these lawyers are doing their job.
All right, Rich, I'm sorry. We got a lot of people here. So what we'll do is we'll go from one mic to the other. Try and keep your comment / question to about 40, 45 seconds so we can get to everybody. And let's open the floor. We'll start over here. Go ahead, sir.
And just so you know, whichever mic you go to, that one's going to move slowest.
I want to thank the speakers for their time and learned opinion tonight. I want to open up by saying that. Mr. Butts, you mentioned about accurate facts, okay? I would like to bring up that, I would like to expand upon that 0.3% number of finding of guilt, okay? We're all familiar with the number, 460,000 alleged sexual assaults every year in Canada is the popular number, correct? Did anybody go and look up what percentage of that 460K did not consider it important enough to report to the police? By the way, it's 60%, so that ticks it down to about 184,000.
We'll let David respond to your question, sir. Thank you very much.
Yeah. I certainly respect the choices of individuals who've experienced something to decide to come forward or not. If they're coming forward, and I'm the first one to say we need to look more deeply at that, I say that you look at the surface and it creates a real perception of a very serious problem in terms of serving that constituency. So let's look a little bit deeper to see if there are ways we can do that better. And even if it is 71% that didn't want to, you still got hundreds of thousands that are not being serviced who would like to be. To me, that's unacceptable. So that's how I'd respond to that. Thanks.
Can I just add a little tiny bit too, though, is that the 460,000 comes from a self-reported, I forget what it's called now, but there's two ways that we count sex assaults in this country. One is the police-reported sex assault, and the other is in a survey conducted every 5 years where they do a random phone thing and they ask Canadians, have you been, robbed, has your car been broken into, and then they get into sexual violence. So I think any smart person or reasonably well-informed person looks with some degree of skepticism upon any kind of self-reporting. Because it's very easy on a phone to say, I was beaten up, or
Right.
so those are some of the apples and oranges we mix up.
Yeah, it's called the General Social Survey, and you can find it online, and all the statistics, all the numbers are there.
Okay, we'll move over to this mic.
Good evening. My first question, at least for now, in regards to the treatment of the accused, some people, especially in light of the Ghomeshi trial, have suggested that the accused name should be kept anonymous until the case is resolved ultimately. What are the benefits to this approach beyond protecting the reputation of that accused individual?
Well, I'm almost at the point where I think that would be a wise idea, just because I've seen the ramifications and the effects on people who are accused. I think the actual solution is to not protect anybody in the courts, frankly. I think nobody should have a pub ban on their name. I mean, the courts are rough places. That's what it's all about. I covered a trial, I think last fall, where 2 doctors were charged with gang sex assault upon a woman. Actually upon 2 women in separate incidents. In any case, I did a little experiment and I didn't use their names because I've been alarmed by some of what I've seen. It didn't matter a pinch because my colleagues were covering it and they were all using the names. They weren't bound by my silly experiment, but it was certainly possible to cover in as great detail and all of that, the trial, without using the accused name. And they were, in the end, acquitted. But the interesting thing was that every single other key participant, both the 2 women who claimed they'd been sexually assaulted and a woman who was a witness, all had pub bans on their names. And it just struck me as so fundamentally unfair.
Yeah. I used to argue against pub bans for many years. David, the rationale behind a pub ban was to make people come forward if they knew, but did it actually work?
No, and that's why I say we need to move outside of the criminal justice system. I mean, we've been tinkering with reforms for 30 years, and we're not making a dent in the reporting rate. So, that was one thoughtful idea at the time. I got to say, I don't have a strong view. I think, Christie, there's an IV tube and a drip bag out there. But
all right. Thank you, sir. Go ahead. We got that mic working over there? Hang on one second.
Microphone.
Can we get the microphone over there working?
I can just project. I'm a loudspeaker.
Oh, you're
Hello?
doing well.
Oh, very well. So it's my understanding that on the defendant side, for the same crimes, males and females generally have a bit of a disparity in the sentencing. More likely to be sentenced if a male, more likely to receive a harsher sentence. Please correct me if I'm wrong there, specifically the lawyers on the panel. As a general trend, that would...
You're talking about somebody who was found guilty.
Yes, when you're found guilty, you are a little bit harsher treated as a male, especially in violent crime. Am I wrong here?
Anecdotally, I think you're right.
Without the stats in front of you, would you give
a...
a...
example. I mean, it's nuanced, but it's a pretty good example.
Well, David and Richard, your clients through the years, male and female, did you notice a difference?
I'd be hard pressed to be able to say off the top of my head that I can attribute differences in sentencing in any kind of broad patterned way to gender. There's so many specific factors that come into play in sentencing.
Now I'm specifically just talking about the raw data, not the motivation. You will find that men have longer sentences, more likely to be percentage-wise found guilty, etc. These are stats I'm looking at, maybe for America, maybe not for Canada, but I'm not talking as to the motivation, just specifically the numbers at the end.
I don't know the specific numbers that you're referring to, I'll be frank with you, but I do appreciate during my practice and speaking to my colleagues that there certainly seems to be a different attitude of the state and the prosecution, perhaps, when a man and a woman are jointly accused of an offense.
Now I had a question actually to follow that,
all right, well,
that statement. So depending on how you take that initial statement of fact to be factual or not, do you guys find, and I'll include you since you've done law as well, either a legal or just a cultural change specifically within courts, law practices, the Crown, etc., that identify this as a problem that exists at all, and if so, any efforts to change that?
All right, I guess you can, I'm not sure how this comes out of the Ghomeshi discussion, but if you want to address it, David.
Yeah, just briefly on sort of a jurisprudential trend. It wasn't very long ago, and it was anathema to even talk about concepts of equality inside of criminal justice, and the Supreme Court in 1999 endorsed the idea in the context of therapeutic records and privacy. So I think we're at very early stages of substantive discussions about equality inside of criminal justice, and I would encourage that conversation to move forward.
All right, we'll move over to you, sir.
Hello. I did see the complete Marie Hennon, or Ghomeshi's lawyer, interview with Peter Mansbridge on the CBC, and I noted in there how she said it's so easy to be brought up for charges like Ghomeshi. She said it's so easy to end up where he did, or where he ended up. And I want to preface this by a little story. I had a girlfriend a while back, and we got into a fight, nothing about sex, but just difference of opinion, and she got mad, and she started saying all these things, and I let her cool down for about a week or so, and then we talked afterwards, and I said, well, all the things you're telling, he said, they're all lies, they're all fabrications. And she goes, quote unquote, I don't care, I was mad. And so the whole thing with Ghomeshi or anyone else who can come up or be brought up on false charges or false allegations, why is there not any sort of onus on the one person who brings the charges up? Like Ghomeshi, I don't know how much he spent on his lawyer, but I heard she charges $1,500 an hour or something like that.
Wow, that's almost as much as you charge, David.
And so I'm sure it cost him a lot of money, but there was no ramifications for bringing up any false allegations or any lying. I need to be blunt.
All right, okay, thank you, sir. Let's talk about it, because people have talked about this in the criminal justice system, and not just in the sexual assault context, about any complainant, that if a complainant comes forward and an accused is then found not guilty, why is there not a public mischief charge immediately laid against the person who may have come forward, especially if a court has found that they either lied or they deceived the court or whatever? Why don't we see those things? I've heard that question many times.
Sure, and there is a remedy. It's a civil remedy called malicious prosecution, and it's a very high standard to meet. But I mean, to be perfectly blunt, you talk to judges, every single day they go into work, somebody is in front of them lying. So if we were going to have public mischiefs for every liar, we would have to double the court system, because after every case, somebody's going to be facing. So, as a matter of policy, they say, look, if it reaches an egregious level of malicious prosecution, there's a remedy. Short of that, this is what we're here to do, is to, try to find some approximation of truth.
Richard, you wanted to comment?
Yeah, I think the problem is not so much the fact that we shouldn't be necessarily charging people with public mischief, because, of course, you can find a reasonable doubt, as Justice Horkins adverted to in his judgment, without necessarily suggesting that it did not happen, to use the quotation marks, it did not happen. But what about the pre-charge screening? That's, in my view, where the system falls apart in a lot of cases. When a complainant goes into the police office, makes a statement to the police then essentially, that's their investigation. That's the end. That's the beginning, that's the end. The information is sworn, the charge is laid, the person's brought into bail court, and away we go. And it's the old, let's let the courts figure it out attitude of the investigating agencies that do not actually investigate, that do not even in a preliminary way test the reliability or the credibility of the allegations before somebody's actually charged with a crime. And once you're in that system, good luck, because then you have to go through a process of a Crown pretrial meeting, but you're already engaged in the criminal justice system. Your name is already in the media releases being charged, and all of those things continue down the road until eventually, if you have a trial, you may well be acquitted.
Can I just respond to that? I take a very different view, because Richard is arguing for increased screening by police and Crown attorneys. That happens privately in an office. That happens for reasons that we can never know. I, for one, want openness and transparency. I don't want those officials deciding what cases will go forward and what will not, for whatever motives they happen to have, or whatever reason whatever they had for breakfast that morning that disagreed with them. I want openness, so I would disagree that we need more screening.
Hang on one sec. Justin, did...
Yes, actually, we have quite an engaging discussion online. Folks are watching on YouTube. I want to throw in a question, if I may,
Sure.
From Terry Brennan, who's watching from the U.S., and he asks, how would taking cases out of the judiciary differ from rape tribunals on U.S. college campuses with no due process?
I think it's an excellent question, and any fact-finding, adjudicative process that does not adhere to notions of fundamental fairness to all parties, for my money, is not worth the paper it's written on. So if we are going to look at alternatives, we have to look at alternatives that are fundamentally fair to all parties. And I will say that historically we have done this. Superior courts demonstrated themselves incapable of dealing with the dynamics of labor relations. So we transitioned that whole area of disputes to labor relations boards. They were still obliged to be fundamentally fair. We see the same thing with, for example, professional discipline of teachers, doctors, lawyers. That's been transitioned into specialized tribunals that are
So you
still
want to carve
fundamentally
out,
fair.
you want to carve out the sexual assault allegation from the other criminal allegations?
I think that in relationship dynamics, the nuances and the subtleties are not particularly amenable to the blunt standard of proof beyond a reasonable doubt, and we do need more nuance brought to that kind of dispute resolution without sacrificing due process.
I'd like to just bring it back to the Ghomeshi case for a moment, because you've mentioned relationship violence a couple of times, and it is worth noting that there were no relationships in this case. Lucy DeCoutere was on her first date when she was allegedly choked and slapped. Complainant number 1 was on her first real date when the first alleged assault happened, and on her third date, she only went down to see the show that Ghomeshi was then starring in. When the second alleged assault happened, and the third complainant was also on her first date. So I understand the dynamics of, you know, an abusive, intimate relationship. I know how difficult it can be for women or men to leave that kind of relationship, how you can become trapped in it. I covered the case of a really bright, lovely civil servant in Ottawa named Donna Jones, who was killed and beaten and basically left to die in the basement of her home by her husband. That was relationship violence. I think it is not accurate to, and I'm not suggesting you were incorporating Ghomeshi, but we're talking about Ghomeshi. That was not relationship violence. I don't know what it was, but it wasn't relationship violence.
All right, we'll move to this mic. Go ahead, sir.
So, full disclosure, I'm a junior defense lawyer, so I'm addressing obviously a panel of my peers that are seniors.
Except for me. I'm your senior, but I'm
yes, I have. But to be perfectly honest, David, I am having a lot of problems trying to understand the system in general. And I mean, I don't mean to come off as disrespectful, however.
You got to speak.
Sorry. Hello. Hi.
There
Yes,
you
perfect.
go. There you go.
Sorry. So I was going to say, David, I do have some problems trying to understand how your system would work in the first place. I mean, you say that the current system is flawed for whatever reason. So obviously, whether that's the fact that it re-victimizes the complainants, there are reasons why they don't come forward, et cetera, et cetera, et cetera. However, you bring to the civil system, I'll be frank, I don't have much experience in the civil system at all, but from my understanding, the whole discovery process would definitely re-victimize the victim infinitely more, number one. Number two is, would we still have the rape shield laws there in play? What elements of the criminal system would you still have there? Would be the next question. The third question would obviously be something along the lines of, well, okay, what makes it sexual, why is sexual assault so specific to this new system of yours when really what I'm seeing is more an issue of WD, to be perfectly honest here, of, you know, one person versus the other, credibility, etc. Why sexual assault on its own? Why is it so different than any other, you know, sort
Back
of crime?
back to your point about why you feel it's important to carve it out.
Yeah. I think that the dynamics of sexual violence have some unique factors that lend themselves to a more nuanced exploration of what really happened. And I can list them. First of all, unlike many other criminal offenses, you do not have witnesses. You do not have physical evidence. You do not have DNA evidence because the issue is consent. Consent uniquely is invisible. And so that you have a category of crimes. I mean, I'm not talking about the predator who jumps out of the bushes. That's why I'm talking about sexual violence that occurs in a context of a relationship, whether it's a first date, a 15th date, meeting of colleagues, workplace. In those situations, you have these unique dynamics coming together that make them not particularly amenable to proof beyond a reasonable doubt. So we need to recognize that we're not reaching that community, and we need to look at alternatives. So what does the alternative going to look like? Part of the problem, and again, I represent a lot of complainants, it's a large chunk of my practice. Part of the problem is that they have a one-size-fits-all model imposed on them. You want to come forward around an allegation of sexual violence, you will get this treatment. You can have any flavor you want as long as it's chocolate. You don't have any choice. The last thing I'm going to do when that's the dynamic I'm hearing from my clients is say, oh, by the way, me, old white guy, I got another idea. We're going to impose this on you. So I'm raising these ideas as alternatives to address what I see are serious structural problems. But the last thing I'm going to do is suggest that it should be designed and built without broad input from the very community that I say is being underserved.
Go ahead, Richard.
Well, I guess my question is, and following up on this gentleman's question, is in the civil process, the alleged perpetrator has no right to remain silent. He gives up that right that he would have in a criminal process. Is the person making the allegation now going to give up her rights under Section 278 and 276 of the Criminal Code. There has to be a quid pro quo there, because if we're moving to a system where liberty supposedly is not longer at stake, but other important things are, should the complainant then not give up those protections that exist in the criminal sphere?
Just for the benefit of the audience, 276, for example, is the rape shield law where you cannot use discriminatory myths. And so, no, of course not, Richard. I'm not going to suggest that we should reintroduce discriminatory myths that just because somebody has sex with multiple partners, they're less credible, or just because they have sex with multiple partners, they necessarily agreed on this particular occasion. I would never advocate the reintroduction of those kinds of myths. But we do have to look at an alternative way of again, increasing our outreach that remains fundamentally fair.
So what does the complainant give up in this quid pro quo where the accused now is no longer entitled to the presumption of innocence, is no longer entitled to the right to remain silent, and where the state is now investigating and essentially prosecuting a private complaint on behalf of an alleged victim?
See, that's where I disagree that it's a private complaint. I think the sexual violation of anyone in our community, regardless of gender, is a matter of public concern.
Well, then it's treated as a public wrong and it's treated as a crime. That's how we treat public wrongs. We treat them as crimes, and we have the presumption of innocence and the right to remain silent. That's why they're crimes.
And we're treating them really well in terms of the scope of how we're reaching them right now, aren't we? That's my whole point. We need to have broader reach.
I don't mean to interrupt.
All right,
again, but
no, just, you know what, I know,
Okay,
and
fair,
we
fair,
can,
fair.
I'm gonna try and just move it along. Appreciate you, your question. Go ahead.
Hello? Can you hear me?
We can hear you.
All right. This is somewhat of a radical question, but why would we expect good service from a monopoly, given that the courts are a monopoly service? I'm not a lawyer or anything, but I understand just from a few readings that law used to be a private affair. It used to be private arbitration focused on victim restitution. This is centuries back. And I think most people in this room can't imagine law not being a government's monopoly. But why would we expect it to not be costly and time-consuming if we have no other choice but to use it and to fund it?
No, you're quite right. It's also pretty secretive. It's opaque often. It's unaccountable except to its own self. I agree with you. So I don't know what the answer is, but it's still better than the alternatives. And I would say probably even better than, it's unformed. I take David's idea as not yet, got a structure or anything, but the alternatives now are what? 2 MPs in Ottawa are accused of, at first, something called personal misconduct, which later on a media tour is elaborated on anonymously by one of the women, and they lose their careers. They were never charged. There was a lawyer who conducted a private investigation for the Liberal Party. So it's that or the justice system. The justice system is still good, but you're right. You don't expect a lot from it. They don't even have working microphones in most of the courtrooms.
Yeah, that's true.
I always laugh when people say, let's get TV and cameras in the courtroom. I'm all for it, but fat chats, can we get microphones first?
By the way, that's a whole separate discussion, but that would be from an education point of view, put cameras in the courtroom.
Absolutely.
1,000% that there should be there.
I agree.
Online, why don't we go to another one of the questions online? Thank you, sir.
There is a question, but I think part of it's been covered. It's, will the 3 accusers in the Ghomeshi case face perjury, criminal mischief charges?
Not a chance, not a prayer. I'm not sure they should, but even if they should, there isn't a prayer. Kathleen Wynne, in Kathleen Wynne's Ontario, you ain't gonna see that, baby. It's never okay.
I don't think it's even Kathleen Wynne's. I'll go further. I think most people would say you wouldn't see it whoever was the premier of this province.
Bear in mind that in March of the year, now I forget what year it was, 3 months after all of the Ghomeshi revelations, and he was charged, first in the Star, and then he was criminally charged, then this government brings in the It's Not Okay campaign against sexual violence. It's a brilliant bit of public education, but nonetheless, it is telling of the government's position on these matters. That's all I'm saying.
Yes, ma'am.
Hi. My issue that I've been struggling with through this whole process is the post-verdict
discussion where we are putting this down in history out of context. And I think the complainants wanted it judged out of context. And I think we're talking a lot about what happened out of context. I think when we say, well, why did they go back? Well, there's an answer for that apparently, and we're painting everyone with the same brush. And when those of us, especially women, who start asking, well, that doesn't make sense to me, and suddenly I'm judged because, oh, well, you've not been through it or you don't understand. Well, no one knows what I've been through. And, I have to applaud Christie because she gave a perfect example of, there's relationship violence and then there's what happened on this date. There was no power dynamic. So for me, I find it very hard to believe that they were trying to normalize it. I think there was something else at play, but yet, my comment is on the discussion that I, as a woman, cannot ask those questions. I think there's a lot of blanks that need to be filled in. And if, God forbid, we do, I, as a woman, am judged and I'm pounced on, and I'm sure maybe there's some people in here that are very angry with what I'm saying. But the reality is there's a lot that wasn't said, and I'd like to discuss. And as soon as I do, it's not part of the popular narrative, and I'm a traitor to my own gender. But there's lots of things that I question. For example, the third complainant came forward at the 11th hour. Well, if it was just herself and the accused that knew that sex act occurred, she didn't have to come forward. But it makes me wonder, was there something in writing that she knew could pop out the next day that made her think, geez, I better attack this now before it comes back? And we don't know. But I bring that up with people. And suddenly, because I'm not discussing the popular narrative, I'm trying to explore the facts, I'm supposed to judge this out of context. So that's really what I'm putting forward to you. And Christie, my email was one of those in your inbox, by the way.
I was just going to ask you, did you read the judgment?
I did.
Okay, good. And because that to me is always my default position for everybody. I think that we all have to start by reading it and then discuss after.
Go ahead.
Were they going to give an answer?
It wasn't a question. It was.
I just want to sort of say, what is your feedback on the post? Like, there's not much room to breathe in terms of discussing the issue.
Sure, my feedback has been quite positive. I don't spend a lot of time on Twitter and social media, so I'm sure I'm being criticized harshly there. But, what isn't criticized harshly on Twitter? That's why I don't read it. But with people who bothered to send me emails, several hundred of them at least, I think the overwhelming point was they were glad that I'd written it the way I had, and they agreed with the decision. Most of them had read it, so overwhelmingly it's positive. And I agree, it's difficult to be a contrarian or to have an opposite point of view, but we're big girls, we can take it. I'm sure you can.
But opinion is like that, and I still get today. I get emails, and my favorite so far, just because I've been talking about this, was somebody wrote an email and said, "You made more sense, Mr. Honickman, when you had a mustache and a mullet and long hair." So. I had no idea what that means, but I think it was an insult, but I'm not sure. Go ahead.
Okay. I think this is mostly for David. I was going to start by trying to clarify whether you were talking about combing out sexual assault cases in particular, or whether you were suggesting a new model in general across the criminal justice system. But what immediately strikes me when I see the idea of pulling sexual assault cases out of the criminal justice system and into the civil courts, or even further into a mediation or moderation or restorative justice procedure, is that presumably entering into any of these is going to have to, just by its very nature, preclude going into the criminal justice system afterwards. And if it's being done that way, if that's the government response, completely different from whether someone who has gone that route separately suing individually looking for restitution, my immediate response is a lot of advocates are going to jump up and down on you and say, this is not treating sexual assault seriously. They're going to say that this is treating it as though it is something that is compensable by money, rather than what the criminal justice system does, which is supposed to be a wide mixture of things.
Yep. No, it's a very perceptive question, and again, I've represented complainants for well over a decade now, and you know, spoken to countless number of complainants about that. And there's a couple elements to my response to that. First of all, as I mentioned earlier, there will remain a category of cases where the criminal justice system is essential. So I don't propose in any respect an all or nothing. My suggestion is that we broaden the range of social responses available and involve a complainant, so empower a complainant to have some real choice and some real input. And many of what my complainants tell me, my complainant clients tell me, is that I don't care if he ever goes to jail. I don't care if he has a criminal record. I just want a hearing where I think I've got a decent shot at being validated rather than being told the chances of getting a proof beyond a reasonable doubt are a snowball's chance in hell, even though nobody's going to ever say they disbelieve you. So it's a matter of offering alternatives and then in empowering the complainant to be consulted to say, okay, what's going to work for you? And if there are alternatives that will work, say, we can go those routes for you, instead of saying, you got this choice or nothing. So it's a more responsive dynamic that I say will meet a lot of the needs that complainants identify to me. Validation, some form of public statement that this behavior was inappropriate, and where relevant, some kind of remedy that assists along a healing journey a complainant may have.
And Richard, wouldn't your clients, if they said to you, I did it, and you know that it's going to end up in a guilty plea, and David's system is going to allow you to say to your client, perhaps, well, we can get off the criminal justice track here because we're going to go to the butt system, and the butt system is that... Oh, sorry. The David butt system, and we're
thinking
now
of changing my name to Harry.
I didn't want to go there, but Richard, quite honestly, wouldn't this be a something that you would like to be able to say to your client, that he or she's not going to have to plead guilty in a criminal court? They're going to go to some restorative justice, take responsibility, the complainant's going to be validated, and away we go. Would that not be, what I'm trying to ask, an attractive alternative?
No. First of all, I don't think David's scenario suggests that the accused has, I keep calling the person the accused, the alleged perpetrator has any role in deciding which track it goes in. That would, on David's scenario and his appreciation of the power imbalance, it seems to underlie his views of the system, that would be for the complainant to decide which track it goes in. So I don't see that the accused person would have that option. And
if I could just respond to that, absolutely. At every stage of the thing, there's negotiations going on, and as lawyers, we negotiate all the time.
But it would be public negotiations, of course, because we're all in favor of transparency, right?
Exactly. I mean, if he's criminally accused, his name is out there, and he's in a public forum.
Not so much, maybe.
But I mean, and he gives up, and Lorne, he gives up the right to remain silent, the presumption of innocence, and the right to have the other side actually prove something. No, thank you.
Well, we do it with youth. We have diversion, don't we? Where they can get off the criminal justice track and go into diversion. Isn't this sort of similar as to what we're talking about?
I don't think David's suggesting that it's anything like the youth justice.
See, I can understand Richard's adherence to the status quo when his clients can walk, even though the responsible conclusion is that he probably did it. So I want to say, regardless of what those vested interests might be in walking, even though you probably did it, can we do a better job at historical reconstruction? And when we've done that better job, can we respond more appropriately?
All right, let's go to this side.
Just so we understand, the vested interest is preventing miscarriages of justice, and that's what it is.
Well, if you take the position that the civil system is miscarriages of justice, you know, we're across a chasm.
Yeah, we are.
Go ahead.
Hi.
Hi.
First, I'd like to let you know, Mr. Butt, that I disagree with the fact your stance on people's personal sexual lives should be of public interest. I don't agree with that at all. And I think whether it's in a criminal court or a civil court, I don't think it has any business in there. So that's, first, I just wanted to say that. Secondly, I'm the partner of a man who's been falsely accused and who has been wrongly convicted and who is currently in prison. So, pardon me, I'm also nervous. I'm a terrible public speaker. So anyway, this is just to the panel in general, but 3 major things have been stripped from men as a defense when any accusation is made against them since the 1980s. One of them is corroboration, the other one is statute of limitations, and the third one is third-party records. So basically, if a man says, I didn't do it, that crazy bitch is lying, he has 0 defense according to the way our laws are written right now. And if he's absolutely correct and he didn't do it, and that crazy bitch did lie, we are left with no defenses, no safeguards to protect him and his liberty from a false accusation and a wrongful conviction. So I would just like to finish this by saying and asking everybody, what does it say about a society that is more concerned with protecting and giving leeway to liars and people who are of mistaken belief, rather than protecting the rights and freedoms of innocent people?
Okay, so thank you. We touched upon this, the danger of the false allegation that has been there, and I think there's no disagreement. The potential will always be there, and this particular person highlighting the different safeguards that may have been there before that no longer exist, to try and weed out the false allegation.
Yeah, I think, as I said earlier, I don't think any response to this phenomenon worthy of the name a just system could be that if it were not committed as a number one value to accurate fact-finding.
But the concern, I think, that's being expressed, David, is, and especially in the context of historical cases, where a complainant comes forward 20, 25, 30 years later. There is no statute of limitations in Canada, as you know, and it becomes very difficult to defend a case where memories have faded, memories have been influenced by the passage of time. It becomes very, very difficult. And the reforms that have been put in place since the 1980s and the 90s to give broader scope to complainants having their day in court, as it were, in the context of historical cases, have basically eradicated to a large degree the ability of somebody to prove that it didn't happen because they were somewhere else on that particular day in 1973. Those kinds of cases bring unique difficulties for a defendant. And
the exact same difficulties are magnified by a factor of 10 for the prosecution, because it's the prosecution that bears the burden of proof beyond a reasonable doubt, which is a very high degree of certainty.
But once the allegation is made that this happened.
If I can just finish.
Oh, sorry, I didn't know you.
Yeah, the disappearing evidence is, it hurts the prosecution far more than it hurts the defense. So that phenomenon will always be there, disappearing memories over time. It is actually going to differentially impact the prosecution, not the defense. The second point is, in terms of child abuse allegations, and we see this repeatedly, and certainly the Stuckless case is in the news yet again. Many people are not empowered to come forward until into adulthood who have suffered childhood sexual abuse. If we have statutes of limitations, we are essentially saying that we will not respond to those, that disempowerment that the perpetrator of child abuse has also visited upon their victims. So we need to be very careful about statutes of limitations that arbitrarily close people out of the criminal justice system.
I think that's a really good point, especially for allegations that date back to one's childhood. In my faint attempt to bring this always back to the Ghomeshi case, though, I would remind everybody that at the time of the alleged assaults in the Ghomeshi case, the complainants were respectively 32, 33, and 41 years old.
Interesting, and out of that, David, if I could just follow up, because there are, and I know and I know you've said to us why you can't talk specifically about the Ghomeshi case, but you can talk about your years as a Crown attorney. And did you not prosecute sexual assault cases back then?
Yes.
And did you not have to prepare your alleged complainants before they took the stand?
You raise a very interesting question. Some Crown attorneys take a very hands-off approach to complainants. A Crown attorney is a quote-unquote impartial minister of justice who does not represent the complainant, but rather represents this abstract notion of the public good in terms of the justice process. And so they are not the complainant's lawyer. And so as a result, many Crown attorneys feel that it's not their job to work with the complainant. And that's a bit of a structural problem because the complainant does not have access to the kind of legal advice going through the criminal justice system that would be beneficial.
All right. Go ahead, sir.
In rape trials, the emphasis seems to be on what the accuser did or did not do, not what the accused allegedly did. A lot of the time, the alleged actions are never even contested because so much focus has been placed on what the accused did before or after the incident. Why does the court not focus on the alleged incident itself?
I guess because of the same reliability and credibility issues that we talked about before. I mean, in this particular case, the Ghomeshi case, the allegations were 12 and 13 years old. There was no other kind of evidence that there might have been possibly, for instance, if you complain in a contemporaneous way and you've been punched in the head, there might be some visible physical evidence of that. But that was all lost. So the only thing there was the complainants. And it wasn't that, I mean, by the time the complainants, the three of them had finished testifying, there was no reason on God's green earth for the defense to call any witness, or least of all to call their client to the stand. And he has a right not to testify, of course. So it isn't that the focus is on the accusers, it's that the focus is on the evidence, and the only evidence in that case came from the complainants.
But Christie, and just to follow up, and I want to say this to Richard, the most fascinating thing to me, because everybody was talking about Marie Henin, and we heard, and
our first-year law student could have done just as good a job with these complainants, I'm telling you.
But Richard, the interesting part to me, and you know this as a defense counsel, there was no, ever in the cross-examination, there was no alternative narrative put forward that you would, I think a lot of people were expecting. Like, I'm going to suggest to you that you asked for your hair to be pulled, or I'm going to suggest to you that you consented to whatever it was. There was no cross-examination on the alleged incident at all with any of these.
Well, no, that's not true. There was with Lucy de Coutere, because Henin put it to her directly at least twice. I'm suggesting to you, Ms. de Coutere, that this incident never happened.
The entire incident never happened.
Made
but
up out of whole
but
cloth.
But I think what I'm saying, and this goes back to my point about the court of public opinion going into this trial, I think a lot of people were expecting that there was going to be this consent issue that was going to come up. Was there consent or not consent? And that never came up at all.
No, and I think, again, I wasn't at the trial daily, but I followed the coverage and in the Twitter sphere or Twitterverse or whatever it's called now. But there was, as Christie said, there was no reason to
We never
go
got
there
to the stage.
because there was so much, arguably, if you read Justice Horkin's reasons, and they speak for themselves, so much, I think he fairly described in his reasons, insincerity from these witnesses about their explanations for withholding certain information,
right,
for example. And when you get back to where we started this evening with assessments of credibility, as Justice Horkins points out, where a witness is not sincere, and where a finding is made that that witness is not an honest person, then it becomes very difficult to bridge that gap to say then that that person's account of what actually happened is reliable.
Right.
Because insincere witnesses, dishonest witnesses, cannot be trusted to be accurate historians. So that's why, in the context of perhaps this particular case, there wasn't a need, except for Ms. de Coutere, for Marie to go there.
Right. All right, well, In my old days in television, somebody would be talking in my ear, but I think you're talking behind my back right now. So I'm getting the wrap signal, and I want to thank you all. I'm sorry we couldn't get to all the questions.
Can we finish the people who are already standing?
Well, you're asking me. Let me put that question, Chris. Can we get to the people who are already standing? Okay. All right. So why don't
I'll zip through this
Wait,
right
if we
quick.
can do this.
To the panel there, you mentioned about getting the courts in the classroom. I think you will find that under 136.2C of the Courts of Justice.
I think you're absolutely correct.
Okay, number two. Does this whole scenario of we believe not remind, perhaps you are too young to remember this, but the satanic sacrifice hysteria back of the 90s there? Does this we believe situation not kind of remind people of that? And lastly, a young couple goes home, they're both drunk. Who raped who?
Okay. I don't know where to start. Move along. Christie wants us to move along. Okay, go ahead.
What, if anything, made the complainants in the Ghomeshi case atypical? For example, is it common for complainants such as Lucy Decoteur to hire publicists and do multiple media interviews before approaching the police?
I don't think it's common at all, but this was a very modern case. It developed first in the media, and then Lucy Decoteur got the publication ban on her name lifted, and then she did, I think it was 9 or 10 media interviews before she saw the police, and then whatever it was afterwards, for a total of 19. That's certainly not common. And it should be a good object lesson, actually, for people, because if you're going to give press interviews, particularly before you go to the police, they are on the public record, and what you say in those interviews will become fodder for cross-examination. So that's one of the good things to learn from it. It's not typical, though, I don't think.
Thank you, sir.
Thank you.
Go ahead.
My question has to do with some observations I had from reading the news after the trial verdict came out. In Ms. Hadane's interview with Mr. Mansbridge, she said that one thing she instructs all her clients, including Mr. Ghomeshi, is that when they go into the courtroom, she can't guarantee them a victory, but a fair chance. And then I also read that Ms. Decoteur accused her Crown Counsel of cheating her as a client and not informing her properly that Ms. Hadane would increasingly attack her on the stand, and she felt that she went in unprepared. And then I also, as a student, I also had many friends around me, some who were also working at law firms, who just couldn't believe the verdict of the trial without following it at all over the course of the trial and seeing the witness testimony being discredited. And after that announcement that the Ontario government is going to invest more in legal aid for sexual assault alleged victims, do you think we need to focus more investments in just legal aid in general and helping people understand how the legal system works instead of focusing it explicitly on the sexual assault domain?
I'd certainly like to see legal aid get more money and be better funded. It's very hard to qualify for legal aid in this province now. I mean, if you make even a quasi-modest income, it's too much money to qualify, unless it's a big case, a major case, or a certain kind of case. So I think that would be a good idea. And I think, as always, it depends on the quality of your lawyer. The first complainant in the Ghomeshi case, in my view, had a very good lawyer who prepared her very well. The other two complainants had a lawyer who was not as good, was from the civil side. And she spent a lot of time, certainly with the two complainants beforehand, but appears to have not prepared them at all for the rigors of cross-examination. None of that, though, gets the complainants off the hook, in my view, because one of my friends who used to be a court reporter always says that you have to know who to be mad at in any case. There's always lots of blame to go around, whatever it is. This is Tracy Nesley. And in this case, I would say, if you're going to be disappointed or whatever in anybody, at the very top of the triage are the complainants themselves, because they weren't truthful. They were demonstrated to be not truthful. And then I would say you could be mad, certainly, at the police, because I think their investigation, trying to placate the I believe culture, they believed. But they did it at the expense of a good investigation. If they'd done a better investigation, they would have, you know, for instance, the first complainant said that she'd been assaulted in Ghomeshi's bright yellow VW Beetle. That's a pretty distinctive car. He didn't apparently have that car until 6 months after the alleged assault with this woman. But we believe that, and there's some evidence of that, but the cops didn't do a check at the Ministry of Transportation to find out what he actually drove in all those years. They should have. That's a real investigative failure. So the police would be on the second tier of blame, I would say. And I don't even know if there's a third party, maybe, but I'm not sure.
And just in case you haven't read the judgment, the reason that particular car was so vital and why that issue, you may wonder why, who cares? Well,
It was very vital.
It was vital because the first complainant said that the fact that this man owned that particular kind of car, the Beetle, the cute little bug, made her feel more comfortable.
She said it made her feel safe.
Safe going with him into the vehicle. So that's why Justice Horkins, when he, as Christie said, dissected that evidence, that's why it became important to his reasoning process.
All right, and, oh, you just did a...
I know, it was
You look like a guy that was over here before.
It must be.
That's sneaky.
Well, no, okay.
Wow.
Okay. So here's the thing. I just, and I don't mean to be picking on you, David, at all, but I mean, how do you reconcile Blackstone's ratio, right? 17, whatever the hell, right? The fact that, again, better 10, it's basically, and I'll explain to other people who don't know this, because obviously you guys do. It's basically the foundation that our legal system is based on presumption of innocence that says better that 10 guilty persons go free than 1 innocent suffer. I just don't really understand how you can reconcile that with the fact that you're saying our justice system is failing the complainants when given Richard's stats, which really were unbeknownst to me, shows that our justice system is treating them all relatively equally. So that means that what our justice system, which is based on Blackstone's ratio, is failing everybody?
2 points. First of all, if you're treating everybody equally badly, that increases the need for reform. It doesn't justify lack of reform. Second point, I do disagree with Black's ratio. And I'm not going to reverse it. What I'm going to say is we can aspire to do better than that. Why not say, let's let 10 people go so we don't convict 1 wrongly? Why don't we say, let's let everybody go who didn't do it, and let's convict everyone who did. It's that kind of perfection that I think we should be aspiring to.
All right.
Yeah, I don't mean for this to be a gang up on Dave, but actually, I've heard various versions of David's proposal for a lesser court to deal with these crimes. My problem is this, with this proposal, and I've heard various versions of this, so yours is, of course, not the only one, is this that, first, courts are not, you said at one point that, you want victims, alleged victims, to be able to find some validation, and many people have echoed this. My resistance to treating this the way you're doing it is that courts and justice, from what I understand, I'm not a lawyer, there are lawyers here, are not meant to be grocery stores for validation. They're supposed to be specific institutions which don't serve individuals but serve justice instead. And in that case, it looks a little opportunistic to say, well, I can't get a conviction of this fellow, and I can't put this guy in jail for doing this, so I'll lessen the impact, thus giving a greater chance of me being able to do something to him. That doesn't sound to me like any kind of justice. I mean, if the crime was very serious, then certainly it should be treated seriously. And you shouldn't just be able to go shopping around for personal validation, looking to put someone away for a lesser crime, because you don't think you have enough evidence to get them. Either it's serious or it's not. And I worry that your version of your proposal, which is similar to many, doesn't have a lot to do with justice.
It has to do with the fact that if we have a standard of proof that we accept everywhere across our justice system, except in the criminal justice system, that says if somebody probably did something, they will be held responsible for it, I say we need to explore whether that standard in a different context, not a criminal context, can better serve the needs of complainants. Rather than having them walk away saying, everybody agrees that he probably did it, but he's factually innocent. There's a disconnect there that doesn't reach a constituency that is being significantly underrepresented, even on the statistics that Richard and I agree on.
But in that case, though, you're implying that the crime is not as serious as it should be. So therefore, it bothers me that that it does look opportunistic.
Well, the consequences for the defendant, if we were to go outside of the criminal justice model, would be significantly different, and you're absolutely right that it would be not treated as seriously in terms of it wouldn't have the criminal sanction and it wouldn't have incarceration as a possible penalty. My thesis is this, that we're responding inadequately to the phenomenon of sexual violence. We cannot do it adequately with the blunt instrument of the criminal law. We need to introduce a range of tools. So instead of having just a hammer, let's have a few other tools in the toolkit to see if we can't better address the problem.
All right. And we have one more.
Hi, Christie, we came because it was such a relief that you were impartial. And I'm wondering, with the great, when you said the lynch mob, from the get-go, Gian was, it was all over the front news, everywhere across the country. So with the great influence that the press have, should there be maybe more consideration about, these kinds of situations? And why only you?
I don't think it was only me. I think it was just louder, probably, than anybody else. More consideration I would give. I'm quite serious when I say I think people in my business should give serious thought to, not using the names of people, certainly who are accused, or who are arrested and under investigation, maybe not use until they're charged criminally, which would presumably defeat a lot of or might defeat some of the bad publicity. Maybe we shouldn't even use the names of certain kinds of accused until they're convicted. It sounds revolutionary and it feels uncomfortable to me because I believe greatly in the need for transparency in the courts and openness in our society and all of that, but it does seem to me that people are being really harshly punished. So I don't know, I forget now what your question was. See, I baffled myself.
Why only you?
Oh, it wasn't only me. Rosie DiMano wrote, sort of critically of it. Everybody changed their minds somewhat in that courtroom, I do think. But it was such a big trial that one of the entertainment shows had, on the first and second day, I think 3 to 5 people there. I don't think I've ever seen them cover a trial. Chatelaine Magazine covered a trial very well with a good young reporter, but for the very first time. And you could tell the people from the Entertainment Network too, because they had impeccable makeup.
Okay. So, I don't have any impeccable makeup on.
Okay.
I'm sorry, because we're a team here. I just want to follow up on something. You asked about consideration. The fact is that you're talking about 2 slightly different things. Your consideration to the accused once the trial is underway is entirely different from consideration of front page news in today's world, which we've already addressed, of the Twitter sphere and everything else that makes a global issue out of something that may be a very small accusation. In this case, it wasn't. But by simply having this on the front page, as the accusations are made, there is a man, in this case, tarred and feathered before one word is spoken on either side, defense or the accused. And I think that's something that press needs to look at. And I believe, by the way, going back to the statute of limitations, that was addressed in the UK quite recently as a very viable issue that needs to be taken very seriously and reconsidered. And that's all I have to say.
All right. And we can't even get into that. I do a lot of work about reputation management, and we won't talk about clients who go to the press or put on Facebook things and comments, because we could have a whole discussion about the veracity of doing that. You, sir, are 1000% the last question.
Awesome. My question is this. I've been in family court for 10 years, and I had my faith partially restored in the Canadian court system when I saw the levers of justice work in favor over the lynch mob justice system. So, but one thing that nobody's really talked about here, that a lot of cases for domestic violence and abuse actually is used as a severe leverage system, and I've been a victim of this in family court. So those numbers, I have no faith when I see statistics, because I know a lot of guys, I don't know how many people in here might have been involved in the family court entertainment business, but it really is kangaroo court, and it's incredible. Like I was charged with assault, and fortunately, I come out of a media background, so I draped myself in microphones and used the recording to get myself off the hook, but not everyone else is so lucky. And as soon as you're accused of, any kind of domestic assault or abuse in a family court situation, you're basically, you've lost your rights to your child. And therefore, that kind of has to be taken into account when you're looking at this global picture.
So that would be a whole other discussion. And
I appreciate that, but we're
discussion.
talking about abuse and charges of abuse and allegations of abuse.
And the Jamie Nelson case that was mentioned earlier, the guy who was wrongfully convicted of sexual assault and did 1,000 days and change in jail, that allegation came out of a domestic dispute. He was going through a painful, messy child custody battle. And it was one of his wife's friends who was the accuser in that case. And among the many penalties he suffered was that while he was in prison, his wife sort of abandoned their child. The child went into foster care and was adopted by the time he was acquitted.
Yeah. Anyways, that was my question. Thank you for.
Thank you very much, and. I appreciate Christie, Richard, David, thank you so much, and thank you for asking me tonight. And I want to thank everybody, and it was a great discussion, and I know the discussion will be ongoing in this way. Thank you again.
Unfortunately, that is all the time we have. I do want to extend a huge thank you to all three panelists for giving their evening to us. You guys have put forward a lot of really interesting topics, interesting questions, interesting answers, and I think you've given everyone a lot of food for thought. But most of all, I would like to thank Lorne. It's difficult to speak at one of these things, but it's even more difficult to make sure that everything runs smoothly, to bring out the discussion as much as possible. You've done a wonderful job of that. Thank you very much.
And just a few words from the University of Toronto Issues Awareness Society. Just wanted to thank the audience today for being so great and for engaging with these issues and for asking questions. And as a reminder, we are an ongoing lecture series, so please do sign up for our next events outside. We have a sign-up sheet. So thanks very much, everyone. Feel free to look us up on Twitter.
Okay, unfortunately, people are already running out the door, but you may notice that there are little cones on the side of your chairs. Most of them have fallen on the floor by now. But if you would read those very quickly, and if you can, fill them out and throw them in the box outside. It's nothing personal. Just to get an idea of how effective this discussion has been about informing people, and whether it is changing people's minds, or whether a lot of people came in here knowing what to expect. Finally, I do want to thank our sponsor, Cafe. They've helped us to put this together, which is really huge. They've dealt with almost everything as far as logistics, which is not easy on our end. And they've helped this to run very smoothly. It's been a great turnout, and thank you all for coming.